261st District Court is back in session.
All right, Ms. Burgess, you may continue.
Your Honor, point of order, if I may. I noticed that Mr. Hurdlow came in as the corporate representative. As Mr. Machuca is the next witness, there was some chatter about him being a corporate representative. I wanted to make sure he was not watching this online.
Oh, Mr. Machuca is not watching it online.
Thank you. Appreciate that representation, counsel.
All right.
And we're going to pass Mr. Wendler at this point.
Okay, very good. Mr. Brudico?
Thank you, Your Honor. Good morning, Mr. Wendler. Can you hear me?
There we go. Yeah, can you hear me?
I can hear you now. Thank you.
All right, good morning.
Good morning. I just wanted to go quickly back to Exhibit 632, the PA Power Wrestling.
Yeah.
You haven't had any opportunity to consider this exhibit since the break, have you?
No.
And are you sure that this came from Rockfin's website as opposed to PA Power Wrestling's website?
You know what? I think you're right. It was PA Power. I'm just looking at the nav bar at the top. Yes.
Okay, so your previous testimony was not based upon your independent inquiry into the Rockfin website. It's just a document that you were looking at on the screen that caused you to conclude that it was a Rockfin website?
No, I have looked at the Rockfin website. I've also looked at the PA Power website. I was probably just mistaken.
Okay, thank you. So when we go to the subject of competition, which obviously you testified about, when we talk about content, Flow Sports believes that if you're posting content online about sports, you're posting competitive content, period. Is that fair?
If you're posting content online about sports in general?
Yes. Is that your definition of competitive content?
No.
Okay, so what does it have to be for the content to be competitive?
If it was similar content to what we are producing, then you would be competing for eyeballs and which are monetized.
Well, how do you define similar content? If somebody is writing about wrestling, even if it might be something that Flow Sports has never written about, would that be similar content?
Yeah, we go pretty deep in wrestling, so I can't imagine what that would be.
Okay, so if it's content about any sport that you cover, it's competitive. Is that your testimony?
Yes.
Okay, and it doesn't matter, does it, to Flow Sports, whether the medium on which you're consuming this content is free or behind a paywall, does it?
Probably not.
Well, I'm talking about someone who might be reading about wrestling on Twitter. You would consider that to be competitive, correct?
That would, yes, we would be competing for those eyeballs on our channel.
Right.
So.
Right, and it doesn't matter whether the medium broadcasts live events to be competitive. It could be competitive just because they're writing and they don't show any live events at all, correct?
Correct.
Right, and it doesn't matter whether the medium is digital, like a website, or a paper, like a newspaper, does it?
It doesn't. There are still magazines, I believe, that exist in wrestling even.
Right, and all of that's competitive, right?
Yes.
Right. And in fact, Flow Sports believes all of these things are competitors. For example, sports video technology companies, those are competitors to Flow Sports, correct?
I can't say in general. There are specifics that we compete with that target rights and content that we're pursuing.
Yeah, are you familiar with the fact that your company was deposed in this matter? Mr. Machuca testified on behalf of Flow Sports in this matter. Are you aware of that?
No.
Okay. Would it surprise you that Mr. Machuca, testifying on behalf of Flow Sports as its corporate representative, testified unequivocally that sports video technology companies are competitors?
I'm going to object to using an out-of-court statement to cross-examine this witness on someone else's deposition.
Sir, I believe at first you had
Oh,
said.
wait. The judge
Sorry,
on mute.
sorry, I was
Sure.
trying to
Sure.
get my space bar to work as opposed to my mouse to work to unmute. Sorry. Restate the objection?
Certainly, defense counsel is cross-examining with a different person's deposition, which wouldn't even be appropriate for that person. There would have to be a contrary statement made.
I don't know that that's what he's doing exactly. Because he can ask your client or your witness if he has information or if he doesn't have information. So whether or not that information came from some other witness is not necessarily a violation of our rules. But so that we're clear, Mr. Brutico, perhaps you could re-ask your question. Let's see.
Right.
We can do that to avoid, so that it's clear to Ms. Burgess what you're asking her and what whether or not the source of that information is relevant.
Okay. And I would invoke or reference Rule 207 that does not require, of the TRCP, that does not require the information to be contrary for me to be able to read it into the record, Your Honor. So the question was, would it surprise this witness to know that Mr. Machuca, testifying as the Flow Sports corporate rep, testified unequivocally that sports video technology companies are considered by Flow Sports to be competitors of Flow Sports?
Oh, you're on mute again.
I
Judge.
think the question he's asking simply is whether or not Mr. Windler would be surprised by something that Mr. Machuca may have said.
As the
Right,
corporate
and
rep.
characterizing it as unequivocal testimony, which, is.
So your objection is that it assumes a fact that's not yet in evidence?
It is, yes, Judge.
I'll sustain that objection.
Okay, well, I'd like to read to you.
And let me just further point out that whether people are surprised I'm not sure what relevance that, so what if he's surprised? How does it get to any of the issues that I have to decide? So would it be surprising to you question is always a little puzzling to me because I'm not sure why it matters if anybody is surprised or not. But as to the substance, the objection is thus far that your question assumes a fact that's not yet in evidence. I think you can ask him a hypothetical though. If it turns out that that's Mr. Machuca's position, would that cause some concern on his part? You can certainly ask that kind of question if you wish.
Your Honor, can I read Mr. Machuca's testimony into the record from his deposition taken in this matter?
I don't know whether or not Mr. Machuca is going to stand by that, change it, alter it, tell you got it wrong, tell me that the court reporter took it down wrong and he corrected it in his deposition. I don't know. But as I said, you can ask him a hypothetical. If this is Mr. Machuca's position, what about that? Is that consistent or inconsistent with your position? Is it something that Flow adopts or doesn't adopt? You can ask him those questions. You can't really ask him whether he's surprised because we don't care about if he's surprised, but you can ask him some more substantive impact of that statement if in fact that statement that you attribute to Mr. Machuca is accurate. You can certainly ask him that.
Yes, Your Honor. Thank you. And I will do that. But for the future, I would be, for this witness, I would ask whether Your Honor has any objections to me reading into the record under Rule 207 of the TRCP, excerpts from the corporate rep deposition.
I think it might depend on whether we've heard from those witnesses or not. I don't know. Let's take that up at a break and let's try to get through the rest of his testimony this morning.
Okay.
Also, Mr. Machuca is the next witness, so you'll actually get to hear from him directly.
But Your Honor, I mean,
I think we have established that Mr. Brutico may ask Mr. Windler if Mr. Machuca said X, Y, or Z, what his thinking about that is, to the extent that his thinking about that has some relevance on an issue I have to decide. So you can ask a hypothetical question. You can preface the question on whether or not the statement is accurate and was uttered. You, I think, can get where you're trying to go more efficiently than arguing about it with me at the moment. Let's move on.
Thank you, Your Honor. Mr. Wendler, if Mr. Machuca testified unequivocally that Flow Sports believed sports video technology companies were competitors to Flow Sports, would you disagree with that?
Probably not, but it's kind of a generality.
Okay, and if Mr. Machuca testified that professional teams in the NBA or in the NHL were competitors to Flow Sports, would you disagree with that?
Are you saying all professional teams?
Professional teams like the NBA or the NHL?
So where would that stop?
was the
We
question,
work with
that-
professional teams, and so we pursue rights for professional teams. So I don't know if I understand the question.
whether Flow Sports considers professional sporting teams to be competitors to Flow Sports.
There are times when they are, yes.
And there are times when they are, is when they want to broadcast their own events to the world.
There are times when professional teams or leagues acquire additional content beyond their own and we compete for that content.
But when an NBA team or an NHL team or the NBA generally or the NHL generally wants to actually broadcast their own events under their own platform, that would make them a competitor to Flow Sports in Flow Sports minds, correct?
They would be the rights holder in that, in which if we're pursuing those rights, we would be competing against the other entities that are trying to acquire those rights.
Well, aren't you also competing against the professional teams or leagues themselves if they decide to broadcast their own events?
Well, they're the rights holder. They would be our partner that we're pursuing. So I don't know if I would consider them a competitor.
I appreciate your answer, Mr. Wendler, but I think I'm asking a slightly different question. If a rights holder is trying to decide between going with Flow Sports and having their events broadcast on Flow Sports or going it their own and actually broadcasting their events themselves, then the actual rights holder becomes Flow Sports' competitor, does it not?
Well, if they created their own technology and did everything in-house, then they could potentially be that, but I have not come across that. I mean, we were in conversation with an agency yesterday for a professional league, and they're considering, they RFP 20 different partners, right? Big guys like ESPN to platform providers to technology services. So there's a lot of competition across the board to try to acquire these rights.
I understand, but let's take Olympic governing bodies because Mr. Machuca was questioned about that. If, let's say, USA Wrestling or USA Swimming, one of the Olympic governing bodies, decided that they wanted to do their own content, they wanted to stream their own videos, they wanted to do their own written analysis, their own studio shows, they would be competitors with you, wouldn't they?
Yes, they could be if they were doing it on another platform. You know, that's a little murky in just that specific example because a lot of the USOCs are tied into NBC and that deal, and they distribute on that platform, which we would see as competitive.
So if Mr. Machuca had testified unequivocally that in that situation they would be competitors, would you agree or disagree with that?
Yes, I would agree. They're trying to get eyeballs, and they're using advertising models or subscription models for similar content and targeting the same communities that we are.
Yeah, one of my favorite things to do is to watch the LA Dodgers World Champions on MLB Network. And
Now, Mr. Britico, I have to say that I am too from Los Angeles, a Dodger fan, go Dodger Blue. But right now, your favorite things are not the subject of this hearing. So let's not make it about you. Let's just ask him a question and not a sidebar comment, if you would, please.
would you agree that MLB Network, MLB Network, when they broadcast their own baseball games to a paying audience, they're competing with Flow Sports for those events?
You're assuming that MLB Network and MLB are the same entity, which they're not.
It doesn't matter. Would you agree
It does,
that
because they acquire those rights from MLB. So we've
Excuse
talked with MLB.
Excuse me, gentlemen. Let's review the basics. One person gets to speak at a time. We do that. Why? Because if you're all talking at the same time, the rest of us can't take it down. We don't know what you're saying. And more importantly, the court reporter cannot get a clear record. Clarity is important and being able to understand what you're saying. So when you're just arguing with each other, doesn't help any of the rest of us follow what you're saying. One question,
Understood.
one answer. And Mr. Wendler, you don't get to make objections or ask questions. You just answer questions that are posed to you. Mr. Brutico, if he wants to interrupt your answers, will make an objection. Okay? Mr. Brutico, you have the floor.
Thank you, Your Honor. And I apologize. Zoom does make it difficult to sometimes speak while the other is not speaking. Mr. Wendler, the question is, would you consider the MLB network to be a competitor in the situation where the MLB network is broadcasting MLB shows or games? Would you consider that to be a competitor of Flow Sports?
We would not, because we are not pursuing Major League Baseball rights.
Okay, so if you're not pursuing something, you do not consider, at this time, you do not consider it to be a competitor, even if it's in sports.
If it's
Right.
a subject matter that we're not pursuing, our platform goes beyond sports as well. I don't know if you're aware of that.
Did you answer my question as to whether you consider it to be competitive if you're not presently going after the sports vertical?
Correct. If it was in a sport vertical, we were not pursuing, have no plans to pursue rights or content, then I would not see it as competitive.
And what if you had previously pursued that vertical, but then abandoned that vertical? Would you consider it to be a competitor now?
It depends if I mean, it's a hypothetical. I don't know if I can answer.
Well, if you had no plans to pursue it in the future, but you did pursue it in the past, but you do not presently pursue it, would that be a competitor, Mr. Wendler?
It depends on the situation.
What does it depend on?
I mean, why would we not pursue it? I don't know. It's a hypothetical situation. So I don't know. I don't have a specific example to give you because I don't think we've run into that.
Okay. You would agree that Flow Sports considers national print and online publications that cover sports to be competitors, even if they do not do video, correct?
That sounds about right.
And any newspaper with a sports department at all is a competitor to Flow Sports, correct?
So I don't know if the way that it was questioned, because I don't know of a newspaper that doesn't have a digital platform as well. I don't think that exists anymore.
But you testified previously that it didn't have to be digital to be a competitor. Did you not, Mr. Wendler?
It doesn't have to be.
Okay. So any newspaper with a sports department, Flow Sports considers to be a competitor, correct?
I can't speak to what they're covering. So I don't know if they're a competitor or not.
So are you saying that if they don't cover any of the 26 verticals, they may not be a competitor, but otherwise they would be? Is that your testimony?
I think so, yes.
Okay. Netflix. Flow Sports considers Netflix to be a competitor, doesn't it?
They're starting to become a competitor. They're doing more and more sports documentaries and sports content. They haven't moved into other forms. So it's a very singular area of competition that's not a huge part of our business, but is a part of our business.
So the answer to my question is yes, they are a current competitor, correct?
Yes.
Okay, and Hulu, you consider them to be a current competitor too, don't you?
What part of Hulu?
Hulu, the entity, do you consider them to be a competitor or not, Mr. Wendler?
Well, Hulu is a virtual MVPD.
Not my question.
So they're just a distributor of networks. So it's like cable.
So the question is
Yes,
not
it is.
what is their business model? The question is whether or not Flow Sports, in your opinion, considers them to be a competitor. Yes or no?
So as a cable distributor, no.
What about as a provider of content?
Are they providing sport-specific content that overlaps with our area, our current communities?
Once again, the question is about what you think and what your opinion is. You don't get to ask Mr. Brudico
Yeah.
questions.
I don't know. I haven't looked closely at their model. I have not personally run into them from a competitive standpoint recently.
So if Mr. Machuca, as the corporate rep of Flow Sports, testified that yes, Hulu is a competitor, would you agree or disagree with that?
I have the same answer.
Which is that you don't know?
I don't know.
Okay. Twitch, you familiar with Twitch?
Yes,
The live streaming community service, is it not?
yes,
Flow Sports considers that to be a competitor, isn't that right?
yes. We have lost live rights to Twitch.
Okay, and video production companies like Razor Blade Media, Production Hub, and Sports Video Group. Flow Sports considers video production companies to be competitors as well, does it not?
I don't know those entities. We hire video production. They're more of a service. So I don't, unless they're distributing on their own, I would not see them as a competitor.
So if Mr. Machuca testified that Flow Sports did consider certain video production companies to be competitors, would you disagree with him?
I mean, I'd have to understand the full context of the line of questioning.
Okay. What, isn't it true that Flow Sports even considers sports agencies like Wasserman, IMG, and Endeavor as competitors?
Again, when they're distributing content, which some of them are, they are competitors.
Okay, it's a yes or no question, Mr. Wendler. Does Flow Sports consider sports agencies such as Wasserman, IMG, and Endeavor to be competitors?
It depends.
It depends on what?
If they're distributing content or just selling content. If they're just selling content, then we would not see them as a competitor. They're our partners.
But any distribution of content makes them a competitor as long as it's in a vertical that you service. Is that right?
Yes, any substantial distribution. Content.
And same answer for sports PR firms. You will consider them to be competitors, correct?
I don't think so.
Okay. Would it surprise? No, I'm not going to ask that question. If Mr. Machuca testified that Flow Sports does consider sports PR firms to be competitors, would you disagree with that?
Yeah, again, I don't know what he was referencing or how the question was asked.
So you don't know.
I don't know.
And how about casinos like Caesars, Wynn, and et cetera? If they had events and they owned an event that they put on, they'd be a competitor to Flow Sports too, wouldn't they?
Well, they distribute lots of events in casinos and now through their apps. So they buy those rights, sometimes from us. A lot of times they try to buy them around us and compete with rights. The more exclusive content is, the more valuable it is. So in that capacity, they can be competitors.
The answer is a yes or no question, Mr. Wendler. Is it yes?
I don't.
I'm sorry, I'm
we-
gonna object to asking my client to be restricted to yes or no if the answer deserves and needs explanation.
It's
So
not
you
clear
further
that
define
it
the
does.
question?
And so if it can be answered yes or no, he should do so. If it requires explanation, he can explain, but let's get some answers that are clear. He knows, he doesn't know, he says yes, he says no, or he can't answer it for some reason because information is lacking. He can certainly explain if explanation is required, but oftentimes it's not. And if he can answer it simply yes or no, he should do so. Mr. Brudico, I'll ask you to re-ask your question so he's clear about what you're asking.
What about casinos like Caesars and the Wynn? Casinos competitors when they own an event and they are considering whether to keep those events and broadcast them themselves.
Can you define how they would broadcast them themselves?
So no, he can't, because for the third time in about 10 minutes, Mr. Winder, I've told you, you don't get to ask him any questions. If you cannot answer the question, a perfectly reasonable answer from you is, I don't know, I don't have enough information to answer that question. That's perfectly okay. But you do not, once again, get to ask counsel questions when they are questioning you on cross-examination. Got it?
Understood, Your Honor.
All right. Next question, Mr. Brudico. I don't think he has been able to tell us the answer to that one.
He did not answer the question, so I'm going to re-ask it again. Does he consider Caesars, the Wynn, and other types of casinos to be competitors where they have events and they are considering broadcasting those events themselves?
I can't answer the question
Why not?
because it's not a real question that comes up, so I don't know how to answer it.
It's a real question, Mr. Wendler, I assure you. So with
When he says that comes up, Mr. Brudico, I think he's not being argumentative with you, but I think by saying when it is not something that comes up, meaning he's not considered it because it's not something he confronts at his employment, I believe is the nature of at least how I took his answer. So I don't think he was trying to be argumentative.
Thank you,
Mr.
Your Honor.
Mr. Wendler, to be clear, are you saying that you don't have enough information to answer that question, or you just are unfamiliar with the details that Mr. Brudico is asking you about, and that's what prevents you from answering the question?
Yes, I don't have enough information and details. It's not something that we've run into, so I don't necessarily have an opinion on that.
Thank you.
Thank you. If Mr. Machuca, on behalf of Flow Sports, testified that if a casino owns an event, that you would be competing with them for that event, would you disagree with that answer?
I have the same answer as my previous one, so the previous question. So,
Okay, which is you don't know.
I don't know.
Now, you think obviously Rockfin is a competitor, that was clear from your testimony, but if Rockfin did not have the ability for its channel partners to live stream live events, isn't it true you would still consider Rockfin to be a competitor?
Sorry, if you're saying can you restate the question clearly?
Yes, you understand that Rockfin operates with channel partners, that PA Power Wrestling that you identified in your testimony is a channel on Rockfin?
Yes.
Yes, okay. And so if, regardless of whether PA Power Wrestling or any other channel partner of Rockfin was able to live stream events, right? Let's say that they couldn't under the technology that Rockfin provided. You would still consider Rockfin to be a competitor, wouldn't you?
If they were offering and selling wrestling content, then yes, I would.
Okay, thank you. And if Rockfin were free, you would still consider Rockfin to be a competitor, wouldn't you?
Yes, we would be competing for eyeballs in the same community.
Right. Now, you also said that Rockfin competes with Flow Sports, but you also talked about Mat Scouts. Mat Scouts is the channel that Mr. Saylor operates on Rockfin, correct?
Yes.
So how does Rockfin compete with Flow Sports as compared to Mat Scouts competing with Flow Sports? Can you distinguish between those two entities?
Yes, you can.
Okay, so can you tell us the differences of competition between Mat Scouts, a channel creator on Rockfin, and Rockfin itself?
So Mad Scouts is the content, right? And they did a partnership, they created a partnership with Rockfin, just like when we create a partnership with Varsity Spirit Cheerleading, we launch a varsity channel and we distribute content that they provide for us. It would be the similar kind of partnership structure. And again, I would see that as competitive to our business.
When you say you provide a channel to it, are you talking about a third party? You give third parties channels on your website?
Mm-hmm.
Is that a yes?
Sorry. Yes,
Okay.
we have, yes.
Okay, and when you do that, do you share revenue with that entity just by giving them free reign to operate however the third party wishes on Flow Sports?
We do not let anyone operate it however they wish and in ways that can be damaging to our business. Obviously, we would prohibit that and try to limit that. But we do have a revenue share structure with that specific party that I mentioned.
Yeah, who is it again? Could you say it again?
Varsity,
Varsity, is that the full Varsity what?
Varsity TV. It's Varsity Spirit, one of the largest cheerleading organizations.
Okay, great. So you had talked about a board deck before, and that was an exhibit that you had talked about in your direct testimony. Do you recall that?
Yeah, the single slide that we talked about.
Yes.
Yes.
So what kind of slide was that in? Was that in a board of directors meeting deck? Was that in a pitch deck for investors? What was that?
It was in a lot of decks, including a pitch deck for investors, pitch deck for partners. It was kind of the slide we use to explain our business at the beginning of a meeting.
Right, and we'll call it a pitch deck then, because I'm going to ask you about pitch decks. It's common in pitch decks to identify competitors, is it not?
Yes, it is.
Okay, and isn't it true that in all of Flow Sports pitch decks, there is no reference to Rockfin as one of those competitors?
I can't speak to all of them. I don't create all of them. I only create a few of them. But yes, we can't list every single competitor across all 25 sports. A lot of it's more of the higher level competitors. And when we be talking about that, that would be typically to investors. So that's what they care about more because they may not be familiar with the Rockfin.
Right, and so you've never seen a pitch deck that identifies Rockfin as a competitor, correct?
Yeah, I haven't seen many decks that identify anyone as a competitor recently.
So the answer to my question is no, you haven't, correct?
I have not.
Okay, thank you.
Correct.
Are you familiar with Patreon?
Vaguely.
Okay, it's a platform, isn't it?
That's what I understand, yes.
It has people who post on all sorts of things and they charge a subscription fee to access the site, correct?
Yes, that's what I understand.
Patreon has wrestling channels on it, doesn't it?
I believe they do.
Yeah. Do you know that whether they have about 10 times more wrestling channels than Rockfin?
I don't know.
Okay. Patreon is clearly a competitor to Flow Sports, correct? Under Flow Sports definition?
Yes, it sounds like it.
Yeah. And content creators are able to live stream any events that they want, assuming that they own the rights to those events. Isn't that true?
Again, I don't have that much familiar with Patreon and their ability to live stream.
So you don't know, or you know, but it's,
I believe
I'm
you. I
sorry,
don't think it's
just to finish with my question. So,
Sure.
so you don't know?
I do not know about live streaming on Patreon.
Okay. Do you know who Wrestling Nomad is? You know that name?
Yes,
His name is, it's a moniker for a person named Dan Lobdell, correct?
correct.
And he was a former employee of Flow Sports, correct?
Correct.
I assume you know him?
I've met him, yes.
Yes. And what was his job at Flow Sports?
He was on the content team for wrestling.
Okay. So like Sailor, he provided non-live event wrestling content for Flow Sports, Flow Wrestling, correct?
Yes,
And now he's no longer employed at Flow Sports. He left over the summer, correct?
yes,
And now he's writing and ranking wrestling on the Patreon platform, isn't he?
I can't speak to that.
You mean you don't know, or you don't, can you explain?
I don't know. Yes, I have not seen, I have not followed him.
Part of the job of a Flow Sports wrestling content provider is to post on social media, correct?
Yes,
You want your content creators to tweet, you want them to post things to create interest in Flow Sports content, right?
yes,
Okay, and do you know who Andrew Spey is?
yes,
He provides wrestling content for Flow Sports, does he not?
yes.
And part of his job is to post on social media about wrestling, right?
Yes.
Okay. Could I have exhibit D104, Hank? Okay, I'm going to ask you about this document, Mr. Wendler.
Mr. Vertico, let me just get some clarity. D104 is not a helpful designation for me. I don't know if that's a defendant Sailor exhibit or if that's a defendant Rofkin exhibit. So I know you all are aligned in some respects. And I don't want to mess up your numbering system, but I need to know whose exhibit this is.
I believe that it's a Rockfin defense exhibit.
You can clarify that. That won't prevent us from moving forward. I don't want to take the time. We can talk about it at the lunch break, but again, clarity and for our purposes and our court reporter's benefit, but also for the appellate record is really important. And so we have two defendants. I need to know which defendant 104 this is. For now,
Here is just one list of exhibits. So we use D number for both defendants.
so you are offering both Rofkin and Sailor are both together offering exhibits as defendants exhibits, and you're not distinguishing between Rofkin or Sailor separately, correct?
Correct.
Okay, so for purposes of the exhibits, all of the exhibits designated D and then a number are offered on behalf of both Rofkin and Sailor?
Correct.
Okay, well, that could get interesting if there's an objection as to one and not the other, but that will be a bridge we can cross if necessary. For now, let's talk about 104, the defendant's joint exhibit 104. Is there any objection to this one, Ms. Burgess?
No objection.
Defendant's exhibit 104 is admitted.
Have you seen this tweet, Mr. Wendler?
I have not.
Okay, well, it comes from Mr. Spey, obviously, whose job it is to post, and this is you know, a posting on Twitter.
Mr. Vertico, it's admitted, but it was without your explanation of what it is. And since you're not testifying, I'm puzzled as to why we would just not hear a question from you. The document's been admitted without objection, and you can ask him about it. What you cannot do is testify about it.
Now, Mr. Wendler, you see that Mr. Spey, as typified by this exhibit, is actually promoting the Wrestling Nomad on Patreon, is he not?
Yeah, I don't, it appears that way. I don't know what his intent was.
Thank you. Okay, now I wanted to ask you about the Nittany Lions event. Nittany Lions is a wrestling club operating, I guess, on a Rockfin channel. Is that your understanding?
Yes,
Okay, and I understand that you testified about an event that occurred in September of this year. Prior to September of this year, Flow Sports did not have an existing contract with the Nittany Lions Wrestling Club, did it?
no, not that I'm aware of.
Right, and you understood that Nittany Lions Wrestling Club owned the rights to this September wrestling event that you testified about, correct?
Correct.
Okay. And you further understood that the club created a Rockfin channel over which to publish that event as well as other wrestling content, correct?
Correct.
Okay, and you further understood that the club, being its own rights holder, could have broadcast the event over any medium it wanted, including YouTube or Facebook for free, correct?
Correct. We don't win every rights that we want. We lose to competitors all the time.
Right, and you consider YouTube and Facebook to be a competitor if they put it on that medium itself, correct?
Yes.
And I assume you're not aware of any communications that the Nittany Lions Wrestling Club had with Rockfin about this event, are you?
I'm aware that Willie Saylor and Kale, the head coach, had communications.
Okay, well, I'm for
Your
the,
Honor, I'm gonna move to strike based on the hearsay testimony of that.
Sailor is an opponent, a party opponent.
I don't know that it's been established that Mr. Windler has any personal knowledge of anything. So it's not clear whether he has personal knowledge or not, but he might have been told by Mr. Saylor, for example, about it. So the motion to strike is not granted, but let's get some clarity. And I think, Mr. Windler, when you are asked about things you know about, the lawyers are asking you about what you know about from your own personal knowledge, what you might have heard from some other people that is not necessarily reliable. So they're asking you about your own knowledge, things you perceived, things you're aware of, not because someone else told you, but because you perceived it on your own, okay? Or participated in some way, were involved in directly. All right, Mr. Brutico, you may proceed.
yes, and so your answer about my question about conversations between the Nittany Lions Wrestling Club and Rockfin, you went straight to Mr. Saylor. And I understand that you believe that Mr. Saylor is affiliated with Rockfin so that you would answer that way, but I'm actually distinguishing between Mr. Saylor and Rockfin from the purposes of my question. You're not aware of any communications that that the Nittany Lions Wrestling Club had with Rockfin about this wrestling event, are you?
I was not part of any conversations between the two parties, no.
Right. And do you know who Kale Sanderson is?
Yes.
Who is he?
He's the head coach of Penn State, and I don't know what his title is with the Nittany Wrestling Club, but the head figure.
Okay, so he's the main person at Nittany Lions Wrestling Club, right?
Correct.
So it's obviously clear that Nittany Lions Wrestling Club, rather than going with Flow Sports, decided to start a Rockfin channel and broadcast it over that. Can we agree on that?
We can.
Okay. And I assume you have no knowledge whether Rockfin played any role in the actual production of the event, that being staging, lighting, filming, editing, etc.
The only thing I have firsthand knowledge of is them promoting the event.
Promoting, is that what you said?
Yes.
So other than promoting, which I do not consider to be production of an event, but other than promoting, you do not have any knowledge of Rockfin's role in any production of the event, correct?
I do not, correct.
Okay. And did you have any discussions with Mr. Sanderson himself?
I did not.
And I assume you know David Weiss, Matt Bowlesby, and Sion Williams,
Yes.
and they're on your team, right?
Sion is not.
Okay.
The other two.
David Weiss and Matt Bowlesby are in the rights acquisition department, and they were trying to convince Mr. Sanderson to broadcast his event on Flow Sports, correct?
Correct.
And isn't it true that when Flow Sports was trying to convince Mr. Sanderson to enter into a deal with Flow Sports, Mr. Sanderson was deciding whether to partner with Flow Sports or just, in his words, doing it on his own?
Hold on just a second. I'm sorry, Judge, you said this witness can't talk about something beyond what he himself had the communications of. I'm okay with him talking about it if he's got general knowledge of what's going on at Flow Sports, but it can't just be one way. That he can only talk about what his personal conversations,
Oh,
except when it's being cross-examined, then he can talk about other people's conversations.
it can be one way because if Mr. Brudico opens a door, Mr. Windler gets to walk through it. So if he wants him to repeat some hearsay, he can ask him a question that calls for hearsay. Because all evidence, as we all learned in first year law school, all evidence is admitted unless objected to. So it could be one way, right? That depends on the question. If he wants him to repeat some hearsay, he can ask him a question, and unless somebody objects, he'll answer it. But if he objects to some other statement as being hearsay, he can also do that. They're mutually exclusive.
Well, I object to
So if his
questions that call for
question-
hearsay unless we can both do that.
It's up to Mr. Brudico to decide whether or not he wants to ask a question that might call for hearsay, and he wants that answer. He does not therefore have to allow hearsay in every other respect, right?
Well, then I object to the questions calling for hearsay.
It's his thing.
Okay, all right. Okay, I have an exhibit that I'd like to show this witness, but it's been marked as AEO by Flow Sports. It's exhibit D194.
Well, we can't,
I'm sorry, did you say 194?
D194.
I'd have to look at it.
we don't have paper copies of these. I need to get another computer where we can see them separately because we have paper copies of.
Well, we'll have to we're going to have a lunch break here pretty soon, so perhaps you'll have time to work out those details and maybe give him an opportunity to review the document so that you're not required to share it on YouTube, but he'll have access to it in case he needs to use it to ask questions. Is D194 a document that is being offered into evidence at some point under some sort of protective order arrangement, or are we not getting this one into evidence? What's the status of D194? Is it objected to? Is it coming in? Is it going to be sealed or something? What's the story?
Well, we do not have the answers to those questions, Your Honor, but to move things along, I will not do this right now, and we will address it over the lunch break.
All right.
But overall, Mr. Wendler, you know that Mr. Sanderson decided to do his own thing rather than sell the broadcast rights to Flow Sports, right?
From my understanding, he decided to distribute his live event in partnership.
Are you finished with your answer?
I
think they're frozen.
frozen.
They appear to be stuck some way. Well, let's give them just a minute to reconnect. I imagine that if they can hear us, they know we have found them to be stuck. If they cannot hear us, I'm sure they have figured out that they have lost us and we'll try to reconnect. So let's just stand by for just a minute. I will ask actually, you probably have Ms. Burgess on speed dial. Now they're gone altogether. So we'll just give them a minute to reconnect. If everybody would just mute their microphones for just a second. I see Ms. Burgess is trying to reconnect now. Someone from the Burgess Law Firm is.
Hi, I just checked on them.
Hi, Ms.
Here. Their whole system just crashed, so they're going to need to restart it.
Okay, we'll just stand by. You know what? Let's do this. Let's take our.
I'll let them know.
Let's just take our lunch break a little early. We have a couple of things to do now anyway, and it's for those of you not in Central Time. That's probably lunchtime for you anyway. So let's do this. Let's just take our lunch recess from now until 12:30. Well, it's not quite an hour, is it? Let's make it 12:45. We'll be in recess until 12:45, but over that break, I would very much appreciate it if you would have a conversation with one another, lawyers, about these exhibits, and let's try to get through some simple ones so we're not wasting time talking about things you don't object to, and we can be more efficient in the use of our time. And I'll ask Ms. Galvez to be sure to convey that to Ms. Burgess, since I don't think she's here to hear me say it. So if you could all just kind of work together on exhibits, that might save us a lot of time in the end.
Well,
And
Your Honor.
let them know that they should take their time to get their tech figured out. We'll just be in recess until 12:45.